just like to reserve a few minutes for rebuttal, Your Honor.
I have to tell you all in advance, I'm not sure that we will require a rebuttal. Particularly if everybody wants another round, I think we may not need that. So we're going to see. We'll see if we need it. Go ahead.
Okay, and I apologize in advance. There will be some overlap, but I have an outline and I will be brief.
Focused is good.
This case is about benefits, Your Honor. It's not funding. Judge Hurd either misunderstood or ignored the distinction carefully outlined by this court in the NJEA case that's been mentioned earlier. There are tens of billions of dollars in pension funds from which to pay COLAs. Whether the legislature appropriates in any particular year is a completely different question from whether promised benefits must be paid. So say if this court in NJEA. There have been years of zero state funding, a number of years of zero state funding, when basic benefits and COLAs have been paid. Benefit payment is not linked directly to appropriations. Appropriations have in fact been made over the last 3 years, although at the 1/7, 2/7, 3/7 rates outlined in the statute. The question in this case is not whether one legislature can bind another to fund pensions or basic benefits or COLAs. The question in this case is whether the non-forfeitable right, which creates a contractual right to receipt of pension benefits, includes COLAs. Judge Hurd's decision mixing funding and benefits is both troubling and broad. His analysis would apply with the same force to basic pension benefits as it does to COLAs. Under Judge Hurd's decision, the legislature could not have promised to pay even basic pension benefits. That directly contravenes NJEA, and this court should not adopt Judge Hurd's analysis lightly. It's a very broad analysis. I want to touch very briefly on sovereign immunity. I don't know if the states can argue it. It's certainly in the briefs. It was addressed in our briefs, and it's a bit of a red herring, as the state constitution's contracts clause protects all of the rights protected under the federal contracts clause. But to the extent that this court feels the need to address that argument, interveners reiterate that the state's position has been uniformly rejected and would effectively write the contracts clause out of the federal constitution, as it would make that clause unenforceable in either federal or state court. There'd be no place to go. The COLA. Judge Hurd never got to the question of whether the non-forfeitable right includes COLAs. He opined that it did. But once this court applies the distinction between benefits and funding identified in NGA, the key question at this point in this litigation is one which Judge Hurd thought that the plaintiffs had a strong argument, namely whether the non-forfeitable right includes COLAs. The Pension Adjustment Act of 1958 explained that COLAs are essential to a pension in order to lessen the diminution of the pension due to the eroding factor of inflation, which has caused significant hardships to retirees. The cost of pension adjustments, as has been said, are rolled into the pension system. COLAs are included in the calculation of the normal cost. There's no separate appropriation of monies for COLAs. All payments for COLAs come out of the retirement system, out of the funds. Plaintiffs in this case can be paid their COLAs for years to come without any additional appropriations. And there's nothing to suggest that there will not continue to be legislative appropriations to the pension systems, which before Chapter 78 required payments of both basic benefits and COLAs. In 1997, the legislature declared that vested members of the pension systems have the non-forfeitable right that we've been talking about. A non-forfeitable right to receive benefits is statutorily defined to mean the benefits program, as Mr. Oslander has said, that it cannot be reduced for any employee for whom the right has attached. What part of the benefits program is excluded? Retiree health benefits. All parties have cited to decisions of other jurisdictions with other constitutional or statutory language. Some find the COLA to be protected, some find the COLA not to be protected. The decision in New Jersey must be based on the language of the New Jersey legislature that enacted the non-forfeitable right to the benefits program, except for post-retirement medical benefits. In 1997, the legislature had already incorporated funding of COLAs into the pension system, had already arranged for payment of COLAs from the pension system, and had even described the COLA as part of retirement benefits in a sponsor statement. This court's NJA decision itself spent considerable time.
I don't mean to cut you off. I know you're carefully prepared, but we've heard argument on the same thing. And we really don't need to hear repetitive argument on the same issue.
I just want to make the point then that even within the NJEA decision, the court went and talked about non-forfeitable rights to benefits, and it did not make any distinction between pension benefits that are protected and pension benefits that are not protected. It didn't make any distinction between parts of the benefits program that are protected and not protected, and neither does the non-forfeitable right, except for retiree medical benefits. The legislature knows how to exclude something when it wants to. So, in conclusion, at this stage of the litigation, interveners ask this court to reverse the trial court's order, find that COLAs are covered by the non-forfeitable rights statute and impaired by Chapter 78. Should the court be unable to find that the impairment was not justified as reasonably necessary to serve an important public purpose, the question that you asked about before, this court should remand for fact-finding on prong 3 of the impairment of contracts test. That's notwithstanding the separate argument about estoppel.
Thank you very much. All right.